still the matter of access to those questions?
Yes, Mr. Peacock. Well, Mr. Davey, perhaps. Can I apologise for keeping you waiting for 5 minutes?
No, on the contrary, I apologise for keeping you waiting for 5 minutes yesterday evening. I spoke to a learned friend and I asked whether he would mind if I just came back on one point from yesterday, having reread the transcript last night, and he's been kind enough to say he doesn't mind if the court doesn't mind. I can deal with it, I hope, in just a couple of minutes. I was reading the transcript last night, and one of the questions that was put to me, one of a number, was by my Lord Justice Nugee. We were talking about situations where you might potentially or arguably have more than one reason or more than one purpose for a particular thing. And the question that I was asked was, how do we, out of a collection of reasons why they paid the money, how do we select one rather than the other for these purposes? By the purposes of section 11.4, that was the question that was put. And the answer I gave was that one has to factor in a number of things. One has to factor in the purpose of the regime, i.e. trying to articulate the true profits, not overstating or understating. One has to factor in the guidance from the Supreme Court, in the case of Tower, in relation to section 11.4. And I also said, in a slightly different place in the transcript, one has to ask why the put option is there in the first place.
Yes.
And one thing that, looking back, wasn't in your Lordship's collection of reasons and was only implicit in my answer was to factor in the call option. Because the call option, just like the put option, ensures that the assets come back within the taxpayer group. It was described as belt and braces, so getting it back by the call option was good enough, FTT 2574.
Yep.
And the call option, objectively, was better than the taxpayer group's point of view. The reason I say that is because a call option, unlike a put option, is in the control of the person who can call.
Yes.
It's within the gift of the taxpayer group to exercise it, contrasting the put option. It wasn't within the taxpayer's gift whether the bank exercised the put option. So they have their own business destiny in their hands rather than waiting for whether the put option will be exercised. Moreover, on the face of things, the call option is better value. It's cheaper for the taxpayer group because they don't have to pay the fee.
The second arrangement fee.
In an effluxion of time situation. If the lease gets to the end of its term, which it did, they don't have to pay the second fee. So you've got a call option which is objectively better because it's within your hands when you exercise it, and it's objectively cheaper because you don't have to pay a further fee. And yet there's no suggestion at all in the FTT's decision that it was ever in the running that the call option would be exercised. Indeed, the finding is that it was virtually certain that the put option would be exercised. FTT 255. Why take that passive, more expensive avenue? I say the answer is because the real purpose, in the meaning of section 11.4, is to obtain the additional allowances.
Which you don't get if the call option is exercised because of a definition of QA, is that right? Or QE and QA.
I think that's right. There may also be a point about it going back to a different company.
Well, I think that is the point.
Oh, that is, yeah.
I think QA, the scheme works, if it works, because on the disposal, deemed disposal, on the termination of the lease, the disposal value is QE minus QA, and you want those two to be the same, so that there's no disposal to reduce your pool. No disposal value to reduce your pool, but QE and QA are only the same, if I've understood this correctly, if the put option is exercised so that it is payable by the lessee, not if the call option is payable, where it's exercisable by another entity. I may be wrong about that.
I think that's right.
If I am wrong, I'm sure Mr. Peacock will correct me.
And equally, if I'm wrong, I'm sure someone from behind me will throw something at me. But that's what I wanted to say.
Well, can I just say, I'm going to ask Mr. Peacock this, but if you want to say anything about it now, do. I've not I've understood entirely that the general purpose of the Capital Allowances Act is what the House of Lords told us in BMBF is to replicate the provision for depreciation, which you can't otherwise get off your profits, although you, in accounting terms, you do take them off your profits, but for income corporation tax purposes, you don't. So it's to provide a measure of relief for depreciation. I have not understood in more granular detail what Parliament's thinking was when enacting the long lease provisions with QE and QA. I'm going to ask Mr. Peacock about that. If you want to say anything about it now, do, but you might want to wait until a reply, or you might want to leave it to Mr. Milne.
I'm grateful for that indication. Out of those options, I'll say nothing for now.
Yes.
And see how things develop.
Thank you. Yes, Mr. Peacock. Have I understood the difference between the put option and call option?
My lord, yes, broadly, but can I come to that in a little while?
In due course, yes, yes. Don't deal with it now.
Well, my lords, my lady, good morning. I propose to address the court by reference to 6 broad headings.
Yes.
First, some observations by way of introduction. Secondly, the transactions here in context. Thirdly, the relevant legislation and how it works. Fourthly, the relevant principles of statutory interpretation and the Ramsey line of cases. Fifth, ground 1. Sixth, ground 2.
Thank you.
So, some observations by way of introduction. It's important in our submission to note a number of things at the outset. So, firstly, the relevant transactions entered into by each of Cape or Altrad and Wiseman are fundamentally the same and involve the same SocGen leasing company counterparty. There's no relevant difference between the two.
No.
Secondly, you've heard a number of expressions or epithets or descriptions from Mr. Milne and Mr. Davey as to these transactions, as to how they would like to characterise or label them. Such labels, such language are, in our submission, of no analytical help. A point I'll make good when we look at the authorities. This is ultimately a question of statutory construction.
How would you characterise them?
They were transactions by way of short-term financing that were designed to give rise to additional capital allowances.
Additional capital allowances. Do you accept that Parliament can't really have intended someone to get 2 lots of capital allowances on the same assets?
I want to come to that in answer to the question your Lordship asked a moment ago about how did the long funding finance lease rules work and how were they intended to work.
Yes, because some of the material that the FTT refers to does make it, I would have thought, plain that this is a set of transactions which is designed to enable someone who has already claimed capital allowances on plant and machinery to claim a second lot of capital allowances on the same plant and machinery without any interruption to their business. Is that a mischaracterisation?
It's slightly too simplistic for a reason I'll come to.
Okay.
But your Lordship, the court will well have in mind that the way capital allowances works is you bring the opening acquisition figure into your pool.
Yes.
Where you've got writing down allowances, which is what we're here concerned with. You take an allowance each year by reference to the statutory percentage and your pool reduces.
Yes.
So conventionally your pool of 100 will reduce to 0 or nearly 0.
It doesn't ever get to 0. If it's 20% a year.
It doesn't ever get to 0. So at 25% allowances, it gets virtually to 0 at about year 13. It never hits 0 because it's a reducing balance.
Yes.
Now, the tax effects of the transactions that we're here concerned with in the period prior to 2011 would be the same in any set of circumstances, however motivated, where a taxpayer with an existing asset on which allowances have been claimed entered into a sale and leaseback transaction where the leaseback was on finance lease terms and the asset was acquired at the end of the lease by the lessee.
Yes.
So it can be said here of these taxpayers that they put themselves in a position where that algebraic or mathematical effect would be true. But that algebraic effect would be true of anybody who had entered into that series of transactions for whatever motive.
Yes, that wasn't quite my question, which is, I mean, I understand that. But what the FTT was referring to is documents at the inception of a transaction and recommendations from the accountants, which put forward the ability to claim the second lot of allowances as the rationale for entering into these transactions. Yes.
And the findings of fact made by the first tier, I did not challenge, and the Upper Tribunal could not challenge, cannot challenge here. I accept all of that.
Thank you.
But ultimately, for reasons I'm going to come to, this is
You say it doesn't make any difference, but I mean, those are the facts, but you say it doesn't make any difference.
correct. And I'm not running away or attempting to slide away or ignore the facts. The facts are as they are.
Yes.
I accept them entirely. But ultimately, it's an exercise of statutory construction.
Of course.
So the question, the relevant questions on this appeal, does a taxpayer sell an asset for capital allowance purposes if he intends to and does reacquire it later? That's the section 61(1)(a) question. Does a taxpayer incur qualifying expenditure if he buys back an asset he used to own? Section 11(4) question. Those questions are generally relevant to the operation of the Capital Allowances Code. They are not particular just to this appeal.
Yes.
So the scope and operation of section 11 and section 61 go to the heart of the Capital Allowances Code and are of general application. Now, these appeals are particularly concerned with the operation of the then relatively new long funding lease regime for capital allowances. Prior to 2006, and for reasons I'll show the court in a little while, the Capital Allowances Code operated by reference to ownership of the assets. If you were the owner, you got the allowances. But there had long been recognition that you might be the lessee under a finance lease, where the accountant said, well, this is not a lease. The lawyers see it as a lease, but we, the accountants, see it as a loan, secured loan. And we're going to leave the asset on your balance sheet because as lessee, you've got all the risks and rewards under the lease. So we, the accountants, think of you as having borrowed money on a secured basis, but the asset's still on your balance sheet. So there was a divorce or a divergence between the legal treatment of a finance lease, whereby if you did a transaction with a bank, a sale and leaseback, the bank became the owner, and prior to 2006, the bank was entitled to the allowances.
Even though the bank's not using it in...
The bank's using it for the purposes of its leasing trade.
Oh, I see. It doesn't need to be a dairy.
No.
Yes.
And that's why the bank
That's why it works in BMBF.
BMBF, because the bank had a leasing trade of a pipeline. It didn't need to be an oil company.
Yes.
Or a gas company in that case. So that was recognised as being an odd feature of the world that didn't quite reflect modern financing. So in 2006...
When you say a finance lease, is that a recognised accounting concept?
It is.
Yes.
It is a lease in which the lessor recovers all or virtually all of his investment in the asset. So typically, if you've got an asset that might have an expected economic life of 20 years, take an aeroplane, you might have a finance lease that extends for that full 20-year period, whereby the lessor will expect to recover the purchase price of the aeroplane over that 20-year period.
Plus the interest cost, the finance cost.
Plus the finance cost. But it doesn't have to be a lease that matches the expected life of the asset. It's still a finance lease if the lessor recovers all of its investment in the asset over the life of the lease. transactions. A finance lease has an accounting meaning in UK GAAP or international financial standards. And it was the reflection of that feature of the world that led to the change in 2006.
Yes.
And so from 2006 onwards, if you are the lessee under particular types of lease, long funding leases,
That's a statutory defined term.
it is, and I'm going to show the court in just a moment.
And is that roughly equivalent to what the accountants call a finance lease?
Yes,
Yes.
there were various tests that had to be satisfied, but one can think of it for present purposes as a finance lease.
Yes.
In those circumstances, the lessee got the allowances
As
Even-
if they owned it. As
as
if,
if they owned it in a world where they weren't actually the owner.
I did want to ask you at some stage, there is a provision, might be section 70A, little 3, which says if you're the lessee under a long finance lease, you're treated for the purpose of this part as owning it.
Yes, I'm going to that's exactly the point I want to make in just a little while.
So at some stage, I'd like, don't do it now, but at the relevant point, why, if in the very same minute that you sell it to the bank, you take a lease back, and you were the owner before you sold it to the bank, and you're treated as the owner immediately after you get it back, why, for the purposes of whatever in the real world, but for the purposes of this part, why are you not treated as still the owner? Well, I mean, how can you say you've ceased to be the owner if the statute says the moment when you dispose of it, you enter into a lease and then you're treated as the owner?
Because you move at the point prior to sale, you are the owner in law.
Yes.
Immediately after sale, you are not the owner in law.
No.
Under the leaseback, you are deemed to be the owner by force of statute.
Yes.
And that's what gives you the access to the allowances.
Yes, but it's the prior question. It's Mr. Milne's question. The cease to be an owner. How can you say I've ceased to be the owner for the purposes of the capital allowances if at the very moment that you dispose of your ownership, you're treated by the Act as if you are the owner?
Because you're owner as lessee under a different provision.
But you're still owner. Anyway,
I'm going to show.
as I say, don't try and answer it now. But it was a point when reading the legislation that I thought, well, I haven't quite understood how that works. And
I'll show you how you move from a Section 61 world
yes,
to a leasing world,
yes,
and then from a leasing world to a Section 11 world.
okay, that's very helpful.
But
in due course.
in due
Yes.
course. For present purposes, the world changed in 2006 so
Yes.
that lessees became entitled to the allowances.
Yes.
Now, the legislation that was introduced in 2006 works by a series of statutory formulae, one of which we're particularly concerned with, QE minus QA plus R. And it was clear in the years after 2006 that that code didn't work as the revenue, and let's assume by inference Parliament had thought that it did. So the legislation's actually changed almost every year in some respects. Our transactions were done in 2010. Revenue didn't like the way that QE minus QA plus R was said to work and changed the law in 2011.
Yes.
The way it changed the law in 2011 was to adjust QE minus QA plus R.
To be precise, the revenue doesn't change the law, but it persuaded Parliament.
It
to change
persuaded
the law.
Parliament to change the law.
Yes.
But the way that Parliament changed the law was to alter the statutory formula
Yes.
and not to adjust Section 11.
Yes.
Where do I come back to?
Do we need to know, have we got somewhere which statute? What we've got is the Capital Allowances Act
2001,
which is a...
as at the 2010-11 year.
Yes. Do we
What
need
you
to...
should have it was a late addition, but right at the back of your authorities bundle is section 33 of the Finance Act 2011.
And that's the one which you say changed the law to correct this particular problem.
It did.
Yes, thank you.
It should be. It was added to the electronic bundle, and I hope it's at the back of volume 3 of the authorities.
And was the 2001 Act a Consolidation Act?
It was a tax law rewrite.
Rewrite,
Act.
yes.
There's a relevant part of the tax law rewrite process I want to show you, of course.
Which started in 97, I think, was it? Or
96 or 97.
Yeah.
But the Capital Allowances Act 2001 was one of those acts.
Yeah. Thank you.
The revenues arguments in the FTT and the Upper Tribunal have now been whittled down to the question of whether taxpayers cease to own the assets, that's ground one, and then new arguments in relation to section 11.4 and the incurring of the further expenditure. But it may be of some relevance to note that the revenue had other arguments below, one of which related to the operation of section 67, which is the hire purchase provision, which was decided against them by the first tier and by the upper tier, not pursued here. And they also had an argument to the effect that once one understands the statutory formula of QE minus QA plus R, the same amount, because it qualifies under section 11 on the repurchase, can't also be double counted in the formula. That was issue 4 before the upper tribunal.
When you say double counted in the formula, you mean feature as part of QA. The amount you're talking about is the price you pay under the put option to
Yes.
acquire, reacquire, and that under your interpretation of the effect of a scheme, both features as part of QA, because it's a residual payment paid by the lessee, and is the purchase price on the reacquisition under 11.4.
Yes.
So it's in that sense that it does double duty.
Yes.
It is a slightly surprising consequence of your argument that the same money can be taken into account for your capital allowance calculations twice.
Yes, I accept that.
Yep.
But that was the revenues argument under issue 4,
And they failed on that.
and they failed on that. And
They
haven't-
failed on that in front of the FTT. And did they appeal it?
They did.
And they failed again.
Yes, and that's, if you may recall, the upper tribunal starts with issue 4.
Yes.
The upper
Yes.
tribunal says it throws some rather helpful light on issue 1.
Yes.
And they haven't pursued that in this court. So your starting point is that the argument about the oddity of that amount doing double duty is not a live issue.
No.
It's accepted. Now, we say, for reasons I'll develop, the upper tribunal were right for the right reasons on ground 1. Develop that in due course. And properly understood, particularly in light of the required assumption and the findings that the FTT actually made, the revenue's new arguments are wrong as a matter of law.
Yes.
Last point by way of introduction, the unagreed bundle.
Yes.
Practice direction makes clear that one should only include documents that are necessary for the purpose of the appeal. The documents in the bundle were before the FTT. They form part of the evidence. We don't seek to contend otherwise. As I said briefly yesterday, we don't mind that you look at the documents, nor could I really object to that process. Our objections as to the use that my learned friend sought to make of the documents. And to reiterate a point that I touched on yesterday, and your lordship put to my learned friend, he can't use those documents to invite this court to make new findings of fact, or draw inferences, new inferences of fact. Indeed, for the purposes of his ground 2 argument, he can't go beyond the facts as found. And he certainly can't use the material to seek to undermine the procedural fairness that this court, in giving permission, sought to establish or ensure by limiting the appeal in effect to grounds of law.
Yes. I thought I detected that the main use of them was to add colour to what the FTT had said in terms of the same minute being used for the sale and leaseback, and the fact that the they're not milk floats, lorries and fridges aren't actually delivered to the bank. But neither of those seem to me to change the facts or the argument, but just to bring home what was really going on. But I thought that was really what use was made of them.
I do have some observations to make in due course, but ultimately, I say to this court respectfully, there's no need to go beyond the facts as found, and there is nothing relevant to the statutory inquiry in the material you looked at yesterday.
Yes, thank you.
But one does have to bear in mind that this was put to this court at the permission stage on the basis that it would be entirely a matter of law.
Yes.
My own friend thought the case slightly differently yesterday.
Right.
You are being asked to address a new point of law without the benefit of a judgment of the first tier or the upper tier, where the first tier made findings of fact, but those findings of fact were not directed to this argument.
Yes.
Now, that is not an absolute bar.
Well, the facts don't change depending on which argument you run. The facts are the facts.
But the significance of the facts in the minds of the decision maker here, the first tier and then the upper tribunal, it needs always to be borne in mind that the finding of fact exercise is necessarily shaped by the form of the arguments before the fact-finding body.
Yes.
So this court needs to be wary of what exactly it is being asked to do in relation to the facts, insofar as those facts are relevant to ground two.
Yes. Thank you.
So that's all I need to say by way of opening. My second heading was the transactions. Now you have the basic building blocks now well in mind. So the taxpayers sold the assets to a company in the SocGen group. SocGen leased the assets back to the taxpayers. SocGen had the benefit of a put option. Another company in the taxpayer group had a call option. As matters turned out, the first tier found was always likely or highly likely, the put option was exercised and the assets were reacquired. Now, in capital allowances terms, again, I'll come to the legislation in just a moment.
Can I just pause there? One of the reasons why the FTT found that it was always highly likely that the put option would be exercised rather than the call option was that it was only if the put option were exercised that SocGen would get the second fee. But I can't quite remember if that was only in relation to one of the two transactions, or was it in relation to both of them?
It was in relation to both of them. I'll be corrected from behind if that's not right, but my recollection it was in relation to both of them.
Yes.
I have a feeling, nothing may tell on this, that in one of the cases, I forget which, the size of the second fee as opposed to the first was substantially greater.
Yes. I think that's not, the quantum of the fee is not the same in each case.
No, it's also, they do differ in terms not just of quantum, but also of relative size to the first fee.
Yes. I can, Mr. Elliott can
But you,
I
check
suspect
that.
all that is interesting but irrelevant. But
I'm ultimately going to say, my lord, just that.
Yeah.
And Mr. Elliott can check if my recollection is right. But for my part, when we come to the relevant statutory question, that's not a relevant factor or feature.
thank you.
But the fact that there was, on any view, a substantial second fee is potentially material, or at least, I mean,
It allowed the first tier to reach its conclusion,
yes.
I think strictly an inference from fact, that the put option was likely or highly likely to be exercised. I have to accept that.
Thank you.
But it doesn't go further than that. We've taken all the colour from that feature in arriving at the conclusion of the likelihood of the exercise of the put options. So in capital allowances terms, and for reasons I'll show you in a moment, that is a sale by the original owner. That should be seen as a disposal event giving rise to a disposal value. You then have a lease of the assets by the new owner under what was a long funding finance lease, such that the lessee was then entitled to the allowances. That lease terminates by a fluxion of time, such that there is a requirement to bring in a disposal value depending upon QE minus QA plus R. And then there is a reacquisition by the former lessee pursuant to the put option, which gives rise to an entitlement to the allowances on the reacquisition. Now, we say as a matter of fact, once one understands the purpose and the grain of the legislative code as a whole, those are the right answers as a matter of principle. And it may help, like I sense the court has this well in mind. We had a simple example.
The 100.
The 100. And just so that you can see it, it's in the second supplementary volume, tab 23, page 445.
So sorry, which page?
445, tab 25.
445.
A worked example.
The worked example. Now, the numbers are illustrative. But we assumed, looking at the left-hand column, your first acquisition as a taxpayer, say in 2006, you acquired kit for 200. And between 2006 and 2010, you'd taken writing down allowances of 120.
And it's a percentage, same percentage each year, but it's a percentage of what's left in the pool.
Yes.
And what was the percentage? Was it 20%, 25%?
At that point, it
Varied?
was 25.
Right.
There is a point I want to come back to about the big purpose of the regime and about depreciation of the rate, but I'll come to that in a little while. So mathematically, the 120 is not right.
No, I was going to say it doesn't look quite right.
It's not, deliberately, just to make the numbers easier
Yes.
to understand from then on. So your tax written down value in 2010, i.e. the value in the pool after allowances, has fallen to 80. So you then sell the assets at a point when they're worth 100. And because you've sold it for more than the tax written down value, you then have to ask, well, is there a balancing charge or a balancing allowance? Because if you sell at 70, you haven't had enough allowances because it's fallen faster than you're writing down. But if you sell at 100, you've had too much. So in this instance, there's a balancing charge because you've depreciated it for tax purposes faster than the market value has actually fallen.
So you have to include 20 in your corporation tax returns.
But you bring 100 into the pool, and if there were no other transactions, that 20 would be a chargeable receipt.
And this is not a separate tax. It gets fed through into corporation taxes.
Ultimately, a balancing charge is a taxable receipt, and a balancing allowance is a taxable deduction.
Yes.
It's through section 247 of the Capital Allowances Act 2001. It feeds into the Corporation Tax Act.
And if you were an individual, it would feed into your income tax.
Into your income tax computations. So in this instance, if nothing else happened, there would be a charge to reflect the fact that you'd had 20 allowances too many.
Yep.
But you enter into a lease-back arrangement where we assume it's a finance lease within the regime, which I'll show you in a moment, which requires you to identify the minimum payments under the lease, call it 5, and the residual amount that's guaranteed by the taxpayer. I'll show this in a moment. 95, and that means that the lessor is going to recover the full 100 that is paid for the asset. And that's one of the things that means it's rightly in the regime. So you have a disposal figure of 100 at D1, but you have an acquisition figure of 100 at A2, and that has the effect that a sale and leaseback is tax neutral for capital allowances purposes, and that's the right answer. Then your lease terminates through a fluxion of time, and you're required to bring in a disposal value by reference to the statutory formula. I'll show you this in just a few moments. But what that is doing is to test the expenditure on which you got allowances at the start of the lease and ask, have you had too much by way of allowance or too little? And QE, QA are the amounts which you expect to spend under the lease compared to the amounts you in fact spent under the lease. And if there's a difference, then that is adjusted. If your lease terminates by a fluxion of time and you've paid the amount you expected to pay, then QE minus QA plus R gets you to 0.
What's the R? There's a rebate of something.
If there's a rebate of rentals.
And there's no suggestion
There's
that
no rebate
applies.
here.
Yes.
So if the lease has run according to plan, then you would expect QE minus QA plus R to be 0.
Well, you might. It's noticeable that the residual amount which is brought in at A2 is not an amount which is payable by the taxpayer, but is guaranteed by the taxpayer. You could have a lease which says, at the end of the lease term, the lessor will sell the asset on the open market, and you, the lessee, will guarantee, if that doesn't produce the amount which is the minimum amount payable as a residual value. And in those circumstances, your QA could be rather less than your QE, because you haven't actually paid.
Well, I need to show more of the provisions in
Yes.
a moment, but if I can ask politely, hold that thought, and I'll show you the way the provisions work in a moment.
Yeah.
But if your lease has come to an end by a fluxion of time, and the amounts you've paid were the amounts you expected to pay, QE minus QA is plus R is 0.
Yes.
And that, as a matter of principle, looking at the purpose of those provisions, is the right answer. You then have the reacquisition, because you're no longer the owner, you need the assets back again, I'll come back to. So you get acquisition 3, where you're buying at the market value, which is now 95, and that is the right answer as a matter of principle. So that's why I said a few moments ago that this calculation is equally applicable to anybody who entered into that series of transactions, however motivated, in the period between 2006 and 2011.
Yep.
Now, 2011, Section 33 of the Finance Act of that year adjusted the definitions of QE and QA. That's recorded in the Upper Tribunal decision, and you have it in the book. It didn't adjust Section 11. The way it's done broadly is to say, if an amount that would otherwise be included in QE and QA is otherwise relievable, brackets, e.g. because you're going to get relief for it under Section 11, is taken out of QE and QA. So what Parliament saw as the problem here was not the amount on which you were entitled to allowances at A3 in our example, but the fact that that 95 was a component part of QE and QA.
If it was taken out of both QE and QA, you get the same result. It still comes out at 0.
But it's taken out of QE
At A2 as well.
at
is it?
A2 as well.
I see. Yes.
And there was a debate below, for reasons perhaps now too abstruse to deal with, as to whether you needed to adjust QE and QA. What Parliament did was to adjust both.
In the worked example, A stands for acquisition, presumably, and D for disposal.
Yes.
Is that the-
Yes. Now, two other points about the transactions. The first here found that these transactions were at arm's length. So as regards the sales, that's paragraphs 46.1 and 59.1. And as regards the leases, that's paragraphs 44.3c and 59.2. Equally, the first tier concluded that there was here a sale. That's paragraphs 44 and 59.1. There was a lease. 44.3 and 59.2. The rent was paid under the lease. The lease terminated by a fluxion of time, paragraph 52 and 59.2. And the put option was exercised, that's paragraphs 52, 65 and 67. So these were ostensibly all legally effective transactions. I say ostensibly because ground one is, well, there wasn't really a sale.
I'm not sure that's entirely right. I thought the revenues argument was for legal purposes there was a sale, but for capital allowances purposes that doesn't count, which is not quite the same point.
I expressed it too pithily, but for capital allowances purposes, notwithstanding there was a sale in law, there was no cessation to own the asset.
Yes, I think that's a better characterisation of the argument.
And I still, for various reasons I'll come to, I say that's wrong.
Yeah.
So that's what I need to say about the transactions. The legislation, starting with the broad purpose of capital allowances, there is authority for this, it's in the MBF, one scarcely needs it, but capital allowances are broadly aimed at giving relief for depreciation. Now, capital allowances are not always available. You can spend capital expenditure on an asset and not get capital allowances. For example, something that doesn't meet the common law notion of plant. Lord Justice Henderson will recall from cases various. So you don't automatically get it, even if you buy an asset that depreciates. Equally, the quantum or the rate of allowances doesn't necessarily reflect the commercial rate of depreciation. So at the relevant points we're concerned with, there were three features of the code. If you bought what I might call an ordinary piece of plant machinery, you got writing down allowances at 25%. That was recognised as being too generous if your asset was a very long life asset. So there was a separate long life asset regime where you only got allowances at 4% to reflect the fact that depreciation would be lower.
Such as what sort of assets only get depreciated at 4%?
Things like large concrete structures.
Buildings.
Some buildings.
Some buildings.
Yes.
Yeah.
Think of vast concrete parts of power stations that might have a 50-year life.
Yes.
So things like that,
Sort of
25%.
Yes, the kind of concrete chamber which holds a nuclear reactor might be an example.
Might
One
be
that definitely needs to have a long life.
A very good example. So the dome you build over a new nuclear reactor, you expect to have a life of at least 50 years.
One would hope.
One would hope. So in those circumstances, a writing down allowance that gives you the economic benefit by year 13 is way too generous.
But these sort of assets, fridges and lorries and so on, they'd be ordinary.
These were
Right.
ordinary.
Yeah.
At a later point in life, there was also a thing called a short-term asset. So if your asset was going to depreciate over 3 years, say,
You could get a more generous allowance.
last feature of the Act, at various points in time, Parliament has said, well, a writing down allowance of 25% is not generous enough. So we want to over-incentivise the acquisition of certain types of capital asset, and we will give you a higher rate of allowance.
And you can get up to 100% first year allowance,
And you can get 100% first year allowance.
which Lord Walker said was a powerful incentive to tax
He did.
schemes.
He
Yes.
did. Now, we're not concerned with
No,
first
no,
year
right.
allowances. But you can see, and the current regime gives you 100% write-off up to a numerical limit to encourage people to spend money on capital assets. So the
Does it depend on the size of the enterprise? Are there different limits?
there are, yes,
Yes,
depending on the
I
size
had a
of the
feeling
enterprise.
there was. Yes.
So if I buy a computer, I think I benefit from that. If IBM buy computers, assume they don't.
Yeah.
But the rate of the allowance is not necessarily tied to the rate of depreciation. There are all
Which is
sorts-
an accounting.
which is an accounting
Thing.
thing, not a tax thing. So there's no necessary correlation between the quantum of allowances you get and the depreciation you suffer.
But I don't think accountants would give you 100% first year depreciation
No,
in any circumstances, really.
it's a creature of the tax statutes.
Yes.
So one can't say, it's not useful to say, at a very high level of generality, this is to reflect depreciation. Well, at that level of generality, that's right. My friend put it yesterday that what you want to do is to arrive at the right amount of profits. But that just begs the question of how do we decide what is the right amount of profits? And in order to do that, you've got to look at the statutory code.
Yes.
You can't start with some a priori assumption that the result you must arrive at has to match exactly an accounting rate of depreciation. Now, the Capital Allowances Code, as I said a few moments ago, worked by reference to ownership. And that wasn't an original feature of the code. So the modern Capital Allowances Code was introduced in 1945 as a post-war measure. And at that stage, you didn't need to own the asset. There was a Glaswegian butcher called Mr. Guthrie, who bought a van, paid for it, and the person he was dealing with ran off with the van. So he never got title. And he said, well, I want capital allowances on the amount I paid for the van. At that time, there was no requirement that you came to own the asset. So the Court of Session said you're entitled to the asset. So Guthrie is a case of about 1952.
Sorry, entitled to the allowance.
To the allowance. And in consequence of Guthrie, the law was changed so that you had to be the owner as a result of incurring the expenditure. And that's what you now see in section 11. So since the change made post-Guthrie, the legislation has worked by reference to ownership. So if at that point you could take up the first volume of authorities, if we look briefly at section 4, page, section 11, tab 4, page 29. In 11.1, you have to carry on a qualifying activity. So think of that here as a trade. and you have to incur qualifying expenditure. So it's not said against us here that we didn't incur anything. The debate is about whether we incurred qualifying expenditure.
There's no dispute about your activity being trades.
No.
No.
Nor is there any dispute that what we acquired was a capital asset and therefore the expenditure is capital in nature. So
And there's no dispute that it counts as plant and machinery.
No.
No.
11.4 defines qualifying expenditure, and it has to be capital expenditure agreed on the provision of plant and machinery, wholly or partly for the purposes of the qualifying activity carried on, and B, the person incurring the expenditure owns the plant or machinery as a result of incurring it. So the code then had to make provision for circumstances in which you might enter into a hire purchase contract. And that's behind tab 8 at page 49. Parliament determined to make specific provision for somebody who would buy an asset on HP terms, whereas a matter of general law, you are the lessee, or the bailey, perhaps more accurately, of the asset until you buy it at the end of the term.
That's because you only have an option to buy it.
Typically, you pay, call it rent, for the use of the asset, and you have an option typically to buy it, say, for £1 at the end of the term.
That's different from buying it and paying by instalments. Yes.
And so section 67 says, if you incur capital expenditure on plant and machinery, and B, the expenditure is incurred under a contract providing that the person shall or may become the owner on the performance of the contract, then that takes us to section 2. The plant and machinery is treated for the purposes of this act as owned by the person and not by any other person at any time when he is entitled to the benefit of the contract. So if I buy on HP terms, I'm entitled to capital allowances from day one, even though I may not buy the asset until the end of year 5. And the way that is done is to deem me to be the owner from day one.
What was the reasoning of the tribunals that didn't apply in your case?
Because the argument against us on issue 2 was you had to look at the lease and the put option together.
Yes. So on performance of the contract meant on performance of the put option.
You had to read both together.
Yes.
That's what section 67 provides. And the revenue said, issue 2, well, you don't meet shall become the owner because it's a put option,
yeah.
But you do meet may become the owner because may means might.
Yes.
That argument was rejected in the first tier and in the upper tier.
Because may become means that you have an option.
It's within your control.
Yes, I see.
And it's relevant for another reason. If you're within section 67, you're taken out of the long funding regime.
Yes. Well, that was why they wanted to run the argument. Yes.
So if they were right, if the revenue were right, then this wouldn't have been in the long funding regime. But significantly, when we come to section 61, section 11 requires you to be the owner. Section 67 recognises that the bailey under an HP agreement is not in law the owner, but treats him as the owner.
And this part is what?
Part 2.
And do we...
It's not clear, but all of this is in part 2.
Right, yes. I can see part 2 at the end on page 51 is headed plant and machinery allowances. So all the sections we're looking at
Are in part 2.
Thank you.
So if one turns over to tab 9, this is the long funding regime. Section 70A, subsection 1, applies if a person carrying on a qualifying activity incurs expenditure, whether or not of a capital nature. If you're paying under a lease, the conventional view is part of what you pay is the principal, part of what you pay is the finance cost. So it might have been said, absent those words, well, the finance cost is not relievable. Because an accountant says the money is under a finance lease of principal and interest, and a lawyer says, no, they're rent. So that's avoiding that debate. Whether or not of capital nature on the provision of plant and machinery for the purposes of qualifying activity under a long funding lease. And then 2, under the application of this part in the case of that person, the plant and machinery is to be treated as owned by him at any time when he is the lessee under the long funding lease. And then subsection 3, you're treated as having incurred the capital expenditure as follows. 4, treated as incurred at the commencement of the term of the long funding lease. And 5, the amount varies according whether it's a long funding operating lease or a long funding finance lease. And there were relevant differences. The accountants recognised a concept of a long funding operating lease, which is a hybrid. We're not interested in that, we're only concerned with long funding finance leases. And subsection 7 says if it's a long funding finance lease, the amount of the capital expenditure is to be found in accordance with section 70C.
It was section 70A, subsection 2, that I had in mind when I asked you the question. If under the lease back you're treated as owning it, how can you say that the sale
Causes a cease to own?
Yes.
And I'm going to show you why that.
Yes. Thank you.
But just to finish off the mechanics of the long funding lease regime, here we're directed to 70C, which is behind tab 10, page 54.
There's never been any dispute that these leases qualify as long funding. Long doesn't mean long. 3 weeks is long enough.
Long doesn't mean 3 weeks. So long, a short lease is one that's 5 years or less.
All right.
But if you entered into a sale and lease back where the lease back was a finance lease, you were automatically deemed to be long.
I see. Yes. Thank you.
It does at first blush seem paradoxical, doesn't it? Something which is designed and intended to have an ephemeral life of 3 weeks at the outside should be treated as a long, really in any sense, a long lease.
I entirely agree that that was the force of a different statutory provision that deemed you to be long if your lease back was
Yes.
financed.
We're in the wonderful world of deeming. Well, of course, these sections are all replete with deeming, aren't they?
Well, this is a deemed world to reflect the fact that you're not actually the owner of the asset in law. But it's 70C that tells you how you arrive at commencement PVMLP, and that in subsection 4 is defined by reference to the minimum lease payments, and that takes you to 70YE. And then just to turn, we don't need the detail of this, but 70YE is behind tab 13. And 70YE tells you to look to the payments under the lease together with any residual amount guaranteed by the lessee or a person connected with them.
There was a dispute at one stage about what guarantee meant, but that's no longer alive. Is
No
it?
longer alive.
So there's no dispute that the amount payable under the put option qualifies as an amount guaranteed for these purposes. Is that right?
That's the effect of the Upper Tribunal's decision on issue 4.
Yes.
So at this stage, we don't need the detail, but under the regime, you were to be deemed to be the owner and given allowances to be computed by reference to PVMLP, which is defined in 70YE.
And in your simplified example, it's the 5 and the 95.
It's the 5 and the 95. Now, the regime then had to make provision for what happens when you leave the long funding lease regime. And that's in 70E, tab 11, page 57. So 70E1 operates if you're the lessee under a long funding lease, you have got allowances under 70A, and a relevant event occurs. And 1A tells you that a relevant event occurs if the lease terminates. And at the foot of that page, in the case of that person, it's in subsection 2. Top of the next page, page 58, the relevant event is a disposal event, and you're required to bring in a disposal value. So on leaving the regime, you have a disposal event, and that is what takes us to QE minus QA plus R. So just pausing there, in the ordinary case for capital allowances, you have to show that you're owner. Post Guthrie, section 11.4. If you're buying under an HP agreement, you can be deemed to be the owner, section 67. And if you are the lessee under the right sort of long funding lease, you are also deemed to be the owner, section 70A. And provision is made to check your entitlement to allowances when you leave the long funding lease regime. So then we need to go back to section 61. So we go back to section 60, which is tab 6, page 43. Section 60 defines a disposal event for the purposes of this part of the Act in subsection 2 as an event of a kind that requires a disposal value to be brought into account under this part, whether under section 61(1) or otherwise. It's section 60 subsection 2 that defines a disposal event and takes us to section 61. Section 61 is tab 7, page 45. (61) 1A, person ceases to own the plant or machinery. B, lose possession in a manner that's permanent. C is abandonment of mineral exploration and access equipment. D is ceasing to exist. E is use for a non-qualifying activity. Skip E for a moment. F, the qualifying activity is permanently discontinued, so you end your trade. We're obviously only concerned with A. I'm going to make submissions about reading A in light of the rest of subsection 1. But just note for now, E, the plant and machinery begins to be leased under a long funding lease. Now, if you're a lessor who have acquired the equipment at some point in the past, you have a capital allowances pool because you bought the kit. Absent E, there was no provision that would turn off your existing pool when you started to lease it under a long funding lease. So E is to deal with the world where the lessor moves into the long funding lease regime.
So do you read E as if it said the plant or machinery begins to be leased by the person who has incurred qualifying expenditure.
Yes,
Yes,
in light of subsection 1,
yes,
the opening words.
yes.
But there is no provision on the face of section 61 that expressly addresses the circumstances in which the former owner of equipment sells it and leases it back under a long funding lease. So in a world where we know you're entitled to allowances under the long funding lease regime on day one, the code needs a trigger to bring in the closing value in your original capital allowances pool. And the only trigger to bring in that closing value in your starting capital allowances pool is section 61(1)(a). Where you sell an asset, albeit on terms you're going to lease it back again, section 61(1)(a) applies because you've sold the asset. That brings in a figure of 100 at disposal 1 in my simple example, and then your entitlement to allowances under the long funding lease regime is governed by section 70(a). So when you see cease to own in 61(1)(a), it has to cater for a world in which you sell the asset and lease it back. Because as a matter of law, you have ceased to own, and that is what that provision is designed to do in those circumstances. It runs with the grain of the legislation, because absent that, there is no trigger event to bring a figure in to close your starting capital allowance pool. I quite accept that that's not a complete answer to ground 1, but it's a hugely important feature of the code that we say respectfully this court has to bear in mind when addressing the arguments on ground 1.
Can I, at some stage, ask you a question which I put to both Mr. Mill and Mr. Davey, which is, do you accept that if Mr. Milne is right on ground 1, then none of the other allowances apply?
We had that debate between ourselves before the first tier as to
Yes.
whether logically, conceptually, it would necessarily follow that if we had ceased to own, nothing else would happen for capital allowance purposes. And we came to the conclusion that that was right.
Sorry, when you I think you just said if you had ceased to own. You mean if you had not ceased to own?
If my learned friend is right that we had not ceased to own,
Yes.
then you have to read all the other provisions in light of the fact that there has not been a ceasing to own. So the case against me in the first tier was, if you cease to own, then from a capital allowances point of view, nothing else happened.
Yes.
We accepted that.
Yes. Thank you.
Rightly or wrongly, I still think rightly, logically, that would be the consequence.
And that is because, can I just tease that out?
Because
If you start with the premise that Mr. Mill succeeds in persuading us that you did not cease to own at the point of sale and leaseback, then what?
then most immediately I can't satisfy section 70(a)(1),
Because you've not incurred,
third expenditure on the provision of plant or machinery.
because you already own it.
I already own it.
Yes, I see.
And once 70A1 is turned off,
You never get to
You
the
never
QE,
you
QA.
never get to the end of the leasing regime,
Yes.
and then I can't meet 11.4
Because again, you have,
because I can't be incurring expenditure on reacquiring the kit
yes, I see.
because I still own it.
Thank you, that's very helpful.
And that was no doubt why Mr. Milne's original case was when you fall at 61(1)A and nothing else matters.
I mean, from one point of view, it produces a kind of rather tempting elegance to that way of looking at things, precisely because it nullifies the whole scheme at the head, as it were.
It's a temptation my lord should resist.
I know you're going to firmly resist it, but
Because it is a matter of applying the
of
statute
course,
properly interpreted in light of the code as a whole.
yes. But it's also perhaps material turning the point the other way around, to bear in mind that if the argument is right, then the way it plays out in practice, so to speak, is not conceptually difficult.
Well, I'm going to say when we get to ground 2, my learned friends are wrong about ground 1, which is the hypothesis on which we test
Yes.
ground 2. They have no or virtually no argument left.
Well, that may or may not be so, but of course that does all depend on you persuading us that ground 1 is wrong.
I accept that. But the court should be in no doubt, point I shouldn't repeat, but I will, that this moving between ordinary capital allowances and the long funding lease world on a sale and leaseback is a perfectly ordinary commercial transaction.
And it doesn't depend at all upon someone doing it with a view to getting extra capital allowances. If your case is that if you simply own an asset on which you've taken your capital allowances in the first place, and then you sell and lease it back, you have to operate the code with both section 61(1)A and the long finance lease bits of the code, because otherwise it doesn't work in that perfectly everyday situation.
Correct. That's exactly that point.
And I think the case you're facing is, but it's different if the whole thing is a Ramsey type analysis where you do have those motivations, because in such a case you don't treat it in the way you would treat it if it was a normal commercial transaction, but you treat it as some sort of composite whole. I think that's the case you're facing.
Jump ahead, if it's said that you have continued use of the asset after this ostensible sale,
That would apply to every case of sale and leaseback.
that applies. That proves too much.
I put that to Mr. Milne. I think he accepted that's not enough.
Yeah. So continued use is not enough. An intention to reacquire can't be enough. You may have a lease back where you have an option at the end to buy the kit if you think it's still valuable. An intention to acquire where you actually acquire can't be enough. So what my own friend is left objecting to is either it's a very short period. Well, how short is short and at what point does it make a difference? There is no principled answer to that. Or what he really says is it's the motives you had in doing this that make the difference.
Yes, I think you can put it in a slightly less tendentious way by saying Parliament cannot have intended that these provisions could be operated in such a way that you could obtain a second allowance on kit that you never, in the practical sense, ever disposed of. I think that's what's being said.
And I have two headline answers. The court sees where I'm going. I'm going to show you the relevant bit in Rossendale.
Yes.
Why did the court arrive at the conclusion it did in Rossendale? It wasn't by reference to motive.
No, I understand that.
And secondly, to say at a high level of generality, well, Parliament can't have intended the second lot of allowances.
Doesn't actually tell you which bits of a statute have to be construed in which way.
And if there is a sin here, if the sin was in the computation of QE minus QA, or possibly the double duty of the 95 at that end of the transaction,
And neither of those are actually now in issue.
neither of them are an issue and neither of them are statutorily relevant to the debate about the construction of 61(1)(a)
Or you would say 11.4.
or 11.4.
Thank you. Yes.
So that's what I say about the relevant legislation. My next topic was statutory interpretation Ramsey. Now, it's no doubt common ground between us that we're searching for the intention of Parliament, discerning the intention from the words used, looking at the natural, ordinary meaning of those words when read in the appropriate context. I quite accept that. There's some useful discussion in now quite an old House of Lords case called Frank Jones, Lord Simon, and in a more recent case, the British Citizens case. They're in the bundle at Authorities Volume 1, Tab 20, and Authorities Volume 3, Tab 48. The relevant passages are set out in our skeleton argument at paragraphs 17 and 18. I invite you at some stage to look at those, but we don't need to turn them up now.
What do they say? They say citizens should be able to read an act and know what it means.
In part that, yes, and Lord Simon has some useful guidance. Perhaps it's worth just turning it up if we have our skeleton to hand.
Well, yes, I know. I thought, in a sense, the most important point was what one means by referring to the intention of Parliament, which is a phrase which falls from our lips the whole time. But it's important to bear in mind we're not hypothesising Parliament as a kind of individual with views of its own, but we're looking. It's a metaphorical expression.
Yes.
Referring to the meaning objectively conveyed by the language Parliament has chosen to enact.
My Lord, exactly that. So it's not what some minister may have said, tired at 2:40 in the morning in a committee. That's not.
And nor should we try to conceptualise it as a reasonable individual, sort of surveying the scene and saying, what should I be doing?
If you have our skeleton, it's paragraphs 17 and 18. The relevant parts are there and set out. Lord Simon and Frank Jones, we say, is particularly apposite. We've underlined a passage. The final task is always to ascertain the meaning of what the draftsman has said rather than to ascertain what the draftsman meant to say. So those are valuable starting points for the construction exercise we're engaged upon. What then of the Ramsey line of cases? There was a long, now slightly dull debate in the 1970s and 1980s as to whether there was some judge-made anti-avoidance rule that would be generally applicable, or whether instead Ramsey was a species of statutory interpretation. And one can follow that debate from Ramsey to Furness to Craven and White to McNiven and all the waypoints on the way. That's in effect what the first tier did here. Wasn't a particularly useful exercise because the relevant principles can now be discerned from much more recent authority. But we now know that what is required is a focused approach of looking to the purpose of the relevant statutory provision and looking at the facts, relevant facts, seen in their proper context. I do just want to show you two cases before we get to Rossendale. First is Mawson, save me coming back to it, which is in the second volume of Authorities, tab 34.
Is this BMBF?
EMBF. Mr. Mawson was the Inspector of Tax, and he found himself as the respondent, I think, in the House of Lords twice or three times. So his name's gone down in tax law history, at least. The relevant passage is, the court has this well in mind. So the Ramsey principle begins at paragraph 26, page 534 of the bundle. In particular, what Lord Nichols had to say at paragraph 32. I'm not sure whether we looked at this with my own friend, but paragraph 36, page 536, talking about Carreras and Bernard. Cases such as these gave rise to a view that in the application of any taxing statute, transactions or elements of transactions which had no commercial purpose were to be disregarded. But that is going too far. It provides the two steps which are necessary in the application of any statutory provision. It sets out the two stages again. Mentions Arrowtown. And then paragraph 37, the need to avoid sweeping generalisations about disregarding transactions undertaken for the purpose of tax avoidance was shown by McNiven. Explains how the House decided that way. And 38, McNiven shows the need to focus carefully upon the particular statutory provision and to identify its requirements before one can decide whether circular payments or elements inserted for the purpose of tax avoidance should be disregarded or treated as irrelevant. So you have to look at the particular provision and its requirements. And then I don't invite you at this stage to read the rest of that, but then 39 begins, the present case, like McNiven, illustrates the need for a close analysis of what, on a purposive construction, the statute actually requires. What he goes on to say, where you're concerned with the allowances on the purchase of a pipeline, you have to ask whether section 11 is satisfied. And the fact that the proceeds of the purchase were pushed around in a loop so as to fund in part the acquisition was neither here nor there. But the House arrived at that conclusion by looking at the particular provision and its particular requirements. So 42 crisply puts that point. If the lessee chooses to make arrangements even as a preordained part of the transaction for the sale and leaseback, which results in the bulk of the purchase price being irrevocably committed to paying the rent, that is no concern of the lessor. The second case it's useful just to look at in the run-up to Rossendale is the UBS case.
I'll just ask you, just before you leave BMBF, the 91 million was, I think there was evidence that was what the gas pipeline was worth. It was a proper figure. If they paid 91 million for a pencil, you wouldn't have said, I mean, there would have been different, the analysis would have been different, wouldn't it?
And that is in part, or in large part, what explains Tower when we get there. Because the software in Tower was not worth anything like what was paid for it.
That informs the question of whether it was really paid for the plant in question.
My own friend said it's a case about section 11, and it is, but you only got relief in Tower if not only do you incur capital expenditure, but you had to incur it on the software.
Yes.
Because section 71 of the Act gave you relief, but only if you spent money on the software. So what Tower is about is whether, where you put 25 of your own cash in, and you raise 75 on some financing terms from the person you're dealing with, and you ostensibly spend 100, can it be said you spent 100 on the software, or did you in fact spend 25 on the software and 75 on the benefit of the soft finance that came back to you? The Supreme Court say, in effect, in the Lord's pencil example, you only spent 25 on the software.
Yes.
That didn't arise here because the market value of the pipeline was agreed to be 91 million.
Yeah. Which is why they could say, from BMBF's point of view, it was a perfectly normal transaction in the ordinary course of their trade.
Correct, as a finance lessor.
Yes.
UBS, same volume behind tab 40. This was a case about employment-related securities, and the detail doesn't matter greatly. Can I invite you to turn to what Lord Reid had to say? It begins at paragraph 61, page 656, as a heading of the Ramsey approach. I don't invite the court to do this now, but at some stage, can I invite the court to read from 61 through to 68? But just to note at 65, he's here talking about Barclays Mercantile and some of the earlier cases and picking it up between letters F and G. In each case, the court considered the overall effect of the composite transaction and concluded that on the true construction of the relevant statute, the elements which had been inserted without any purpose other than tax avoidance were of no significance. And it all depends on the construction of the provision in question. And then he said the point is illustrated by Macmillan and Barclays itself. And then 66, he refers to Permanent Judge Riviero in Arrowtown. Yes, that phrase, the ultimate question is whether the relevant statutory provisions construed purposively were intended to apply to the transaction viewed realistically. What Lord Reed says at the top of 67, references to reality should not, however, be misunderstood. In the first place, the approach described in Barclays Mercantile and the earlier cases in this line of authority has nothing to do with the concept of sham. On the contrary, tax avoidance is the spur for executing genuine documents and entering into genuine transactions. Secondly, it might be said that transactions must always be viewed realistically if the alternative is to view them unrealistically. The point is that the facts must be analysed in the light of the statutory provision being applied. If a fact is of no relevance to the application of the statute, then it can be disregarded for that purpose. So 2 points there. One needs to be wary of a plea to reality, because there's a danger we enter into what Lord Hoffman memorably called spooky jurisprudence, where one's perception of reality is governed by a whole series of unprincipled factors. But secondly, and more importantly, what the Supreme Court is saying there is you discern what is a relevant fact or feature, having identified the requirements, including the purpose of the relevant provision. A similar point is made I don't need to read it out, but if one turns to page 664, the way the Supreme Court deal with this case is they consider the construction of the statute, and there's a heading at 85, construction on the purpose, conclusion on the purpose of construction, and then 86, application to the facts. So that is a perfectly good example of the court identifying the purpose and requirements of a particular provision, then discerning what facts or features are relevant to that provision properly understood, and then applying one to the other to arrive at an answer. So if we then turn up Rossendale, for our present purposes is the last word of the Supreme Court. It's in volume 3 of the authorities at tab 46. And this was a debate about the meaning of owner in the rating legislation and what it meant to be entitled to possession of the relevant property. And you have seen Lord Briggs and Lord Leggett speaking on behalf of the court. You've seen the passages that begin paragraph 9, page 822, the Ramsey principle. I think you're invited by my friend to look at 9 through to the end of 17. If you're not at some stage, I ask you to look at those paragraphs, but the key one is paragraph 15 and 16. So 15 is the two-stage process. The first is to ascertain the class of facts intended to be affected by the charge or exemption. This is a process of interpretation of the statutory provision. The second is to discover whether the relevant facts fall within that class. If we then look on at how that was applied in this particular case, there's a heading at paragraph 46, page 832, summary of relevant facts, and then numbered Roman numerals 1 through to 6. Can we just note Roman 1, foot of that page, the leases were not shams, created genuine legal rights. 2, the leases were entered into and the rights under them granted solely for the purpose of avoiding liability to business rates. 3, the leases were not granted with the intent of allowing the SPV to make any use of the property or giving the SPV any role in its being brought back into the use. To the contrary, it was an inherent part of the scheme that the SPV would have no ability to do so. Roman 4, by the same token, the schemes were designed so the practical ability to decide whether to continue to leave the property unoccupied remained with the defendant landlord. For my part, I don't need 5 and 6. Then 47 at the foot of that page, applying the legislation to the alleged facts, there can be no doubt that the definition of owner of a hereditament in section 65(1) as the person entitled to possession of it is to be interpreted as denoting in a normal case the person who, as a matter of law of real property, has the immediate legal right to actual physical possession of the relevant property. And at 48, they say, in the unusual circumstances of this case, however, identifying the person entitled to possession as the person with the immediate legal right to possession of the property would defeat the purpose of the legislation. And you were invited to look at paragraph 49. Parliament cannot sensibly be taken to have intended that the person entitled to possession of an unoccupied property on which the liability for rates is imposed should encompass a company which has no real or practical ability to exercise its legal right to possession, and on which that legal right has been conferred for no purpose other than avoidance of liability for rates. And 50, in these circumstances, we have no difficulty in concluding that on the agreed and assumed facts, the SPVs to which leases were granted did not thereby become entitled to possession. Reading on 6 lines down, this does not involve ignoring the leases in the way that an intermediate element in a circular transaction might be ignored under the Ramsey doctrine. Rather, it involves their close examination in their context, and the conclusion that they did not transfer to the SPVs the entitlement to possession required by the Act as the badge of ownership. And then 51, we emphasise that this conclusion is not founded on the fact that the defendant's only motive in granting the lease was to avoid paying business rates, although that was undoubtedly so. If the leases entered into by the defendants had the effect that they were not liable for business rates, their motive for granting the leases is irrelevant. Nor does it illuminate the legal issues to use words such as artificial or contrived to describe the leases, and it is now accepted that they created genuine legal rights and obligations and were not shams. So the way the Supreme Court arrives at their conclusion is to say that you have to look at the nature of the rights that were held by the ostensible lessees in light of the proper construction of the relevant provision of the Act. And they concluded that those requirements were not met on that fact pattern.
Why then do they say in 49, when they're construing the statutory words, person entitled to possession, they say Parliament cannot be taken to have intended that that should mean, and then they say 2 things. Firstly, a lessee who has no real or practical ability to exercise its legal right. I understand that entirely. But secondly, on which that legal right has been conferred for no purpose other than the avoidance of liability for rates, still less can Parliament rationally be taken to have intended that an entitlement created with the aim of acting unlawfully and abusing procedures should fall within the statutory description. But why are those latter points relevant if all you're looking at is a motiveless inquiry?
I struggle, candidly, to give a complete answer to that, because one reads 49 and it does appear that they have taken account of motive.
Yes.
But when they come to apply a construction of the provision that they have arrived at to the facts of the case, they say explicitly, we have not relied on motive.
The two don't seem entirely consistent.
They do not. I accept that.
I mean, I wonder if what they're saying in 51 is along the lines of, it's not quite how they put it, but this is not, you can't just jump from someone's trying to avoid tax to it doesn't work.
On a different case.
Yes. And that echoes something where it was said in one of the cases that the Ramsey doctrine is not a wide spectrum antibiotic that kills off. This is Lord Hoffman, I think.
It is. It's
McNiven?
it may well be in McNiven.
Yes. So you can't just say snap. It's a tax avoidance scheme, so the Parliament can't have intended it to work. You have to anchor it to a process, the two-stage process of statutory construction, and then applying it to the facts. But that's not inconsistent with saying when looking at the two-stage process, at the first stage, when you're construing the statutory provision, you can take into account what Parliament did or did not intend, using that phrase in the way in which we understand. And in taking into account in that purpose of construction, you can take into account the unlikelihood of Parliament intending to enable a tax avoidance, to enable the statute to be used for tax avoidance. Is that a possible way of reconciling what they're doing?
It is, save that, but I think your Lordship put it slightly too high.
Yes.
One can read 49 as saying when you're conducting that statutory interpretation exercise, you can't close your mind to what is said to be the result of a given construction,
Yes.
where that result may, what you usually look odd.
Yes.
But when they get to applying that construction to the facts, in order to determine that particular appeal, they say explicitly that they're not relying on motivation.
Yes.
Now, that would be a way of reconciling what looks difficult,
Yes.
but I can't say to the court that that's the only way that one can deal with those passages.
We're falling into a trap of construing a judgment as if it were a statute, which it isn't. But it is guidance, and it is the most authoritative and recent guidance, and we have to try and follow it.
Yes.
It was also a strong case in the sense that Parliament expressed, I'm sorry, Parliament, the Supreme Court expressly accepted that in the normal way, you answer the question whether legal right to possession just by looking at the fact you have a relationship with landlord and tenant.
My Lord made this point in the Court of Appeal, and
Well, that was the point, and it seemed, well, I found to say it seemed to be a fairly strong point at the time. But nevertheless, the House of Lords Supreme Court said that is ultimately not
little
enough.
grovelling, I would still say, my Lord, yes, it is a powerful point, but the Supreme Court said in effect it's not quite enough.
Why is it not quite enough? Well, this was again a case where no facts have been found. One has to remember that. It was all a very unsatisfactory case in many ways, not least because it was dealt on a strikeout.
Yes.
And, well, again, the Supreme Court made quite a number of assumptions about what the facts might have been. The relevant provisions, the relevant evidence was very thin and difficult to interpret.
But it is the best current guidance we have.
Undoubtedly, we have to follow it because, as you rightly tell us, I mean, the two-stage process is embedded in it, and it is now too clearly established, certainly to be questioned at this level.
Yes. But I do whatever one wants to think about those references in para 49,
You rely on 51.
I rely on.
Yes.
Yes, no, understood.
So internally, 51 trumps 49 to the extent of any tension between them.
If I'm driven to that point, then I say that, yes.
Yes.
Now, the two other cases you were shown, Clipperton and Hargreaves, with respect, don't add to this debate.
I certainly didn't attempt in Capital to change anything, add anything. I simply tried to apply Rossendale.
You were upholding, as it happens, Judge Morgan in Clipperton on a Ramsey argument where the statutory provision was different and the facts were different.
Yes.
So I asked my learned friend, well, so what? It doesn't tell us anything of particular use for the purposes of this appeal.
But it was an example of looking at a statutory word and construing it and then applying it to the facts.
Yes. And in that case,
Which is what I thought one ought to do.
which is, and I would urge upon this, because that is exactly what you have to do, is to look at the provision in its wider context, discern its requirements in the language, and then see if
Language and purpose.
and Hargreaves, again, it's a Ramsey argument, but on a different statutory provision and again different facts. It's a very reasonable recent example.
Well, again, you're looking at a statutory word. In that case, I think it was entitlement. And trying to work out what that meant in the context.
Yes, beneficial entitlement, where you were the recipient of interest, but you had an obligation in effect to pay it straight away.
Yes.
So for my part, at least, Clipperton and Hargreaves are recent examples, but they don't alter the line of principle. So that would then take me to ground one. So what are the requirements here of section 61? Now, my headline answer, which I'll develop, is that we know from the code as a whole, section 11 triggers capital allowances on becoming the owner of the equipment. Section 61 is designed to be the bookend to that, to trigger either a balancing charge or a balancing allowance in the pool created by section 11 when you sell an asset or otherwise have some other type of disposal event. 61 and 11 are designed to work in tandem. 61(1)(a) asks, did you cease to be the owner? That, I'm going to say, is a question as to whether you have lost the ability to deal with the asset as the legal owner, being the person with beneficial interest and or legal title. Here, with that interpretation of 61(1)(a) in mind, looking at the relevant facts in their context, there is such a loss of ownership at the point of sale, notwithstanding the leaseback and or the length of the lease and or the put option and or the tax motive. Statutory relevant factor is a loss of legal ownership. And that is all that section 61(1)(a) requires. And it is present here.
Yes.
What does ceased to own mean? Here we need to go back to the first volume of authorities, and that's the Mellowish case. House of Lords decision. It's at tab 27. decision of the House of Lords in 1995. This was another leasing transaction involving a Barclays company, BMI number 3 and others. And those companies had entered into leasing transactions with local authorities in relation to assets that were incorporated into buildings. And by being incorporated into buildings, they became fixtures. So as a matter of property law, they became the assets of local authorities. Barclays, because this is a period in which the lessor gets allowances, so you're pre-2006, Barclays said we're entitled to capital allowances, and the revenue said no, because you don't become the owner by virtue of the expenditure you've incurred, because you've been incorporated as fixtures into the buildings that belong to the local authorities.
Were they already fixtures when they were sold to Barclays, sold and leased back? I mean, how does it?
Barclays bought them before installation, I think.
Why didn't they become the owner? Because if you've got a chattel which becomes a fixture on being fixed, when you buy it, it is a chattel.
The point appears, it's in the head note, page 311, between letters C and D. The local authority ordered the equipment.
And caused it to be incorporated in the premises and then submitted an invoice. Yes. So there was never a stage at which Barclays had title to a chattel.
I misremembered that.
Yes.
At the relevant time, this was before the 1990 Act. So we were concerned with what was section 44 of the 1971 Act. And that appears towards the top of page 328. And section 44 is the equivalent of section 11. Section 44 required that the person incurred capital expenditure on the provision of the plant for the purpose of the trade, and in consequence of his incurring the expenditure, the machinery or plant belongs or has belonged to him. So the relevant concept was belong. And the revenue said, well, it never belonged to you, you Barclays, because these were fixtures. And the House of Lords agreed with that conclusion. One can see that in the judgment of Lord Brown Wilkinson, page 329 of the bundle. Reading just from the top of that page below A, this is the Court of Appeal, held that the concept of a fixture which remains personal or removable property was a contradiction in terms and an impossibility in the law. The future right to remove the equipment at the expiry of the term or in the event of a default on a local authority did not mean that the equipment belongs to the taxpayer. And then B, I agree with the conclusion and reasoning of the Court of Appeal.
So I've not on.
Page 329 of the bundle, 473 of the report, at letter A, second line down, the sentence begins, they held that.
Oh, I see. Yes. Yes. Now, what I was didn't understand was the Court of Appeal allowing an appeal against Mr. Justice Weinlott, because if you look at letter H on 328, Mr. Justice Weinlott held the plant did not belong to taxpayer companies, but that's limited to tenanted properties, and that distinction disappears. Yes, I see.
And at B, Lord Brown Wilkinson expresses this in the language of ownership. So such fixtures are in law owned by the owner of the land. And there was then a debate about whether the terms of the lease made any difference. And he concludes that element of the debate at page 331 of the bundle between letters F and G. Says the bundle of rights enjoyed by the taxpayer companies, he concludes is not sufficient to justify describing the agreement as belonging to the taxpayer. Below letter G, the taxpayer company has never been the owner of the equipment. At some stage, I invite you to read the sideline passage that goes down to the top of 333, but in particular, just to note for now at 332 between letters F and G, I reach the conclusion that for the purposes of section 44, property belongs to a person if he is in law or in equity the absolute owner of it. And that was the same conclusion that had been arrived at in an earlier case called Stokes and Costain. One can see over the page, it's Lord Brown Wilkinson says at letter B, page 333, Lord Justice Robert Goff at 771 in Stokes and Costain treated the expression belonging to as the same as owned by. So just for your note, Stokes and Costain is in the first volume of authorities at tab 24. And it's pages 766 through to 771 of the report. Now, the point was taken below, and it appears in my friend's skeleton argument, but wasn't advanced yesterday, as to whether belonged and own are the same. And they are. So hopefully this has made it to the back of volume 3 of your authorities bundle. But this is the tax law rewrite point. I hope you've been provided with a document that's headed right at the top. These notes refer to the Capital Allowances Act 2001.
Yes, tab 53.
Yes, and you should find there note 7. And these are the explanatory notes to the Act. And this is Annex 2 to those notes, where Annex 2 noted where there'd been changes of language, but no intention to change the law. And note 7 records the fact that the language of belongs has become the language of owns. And we are told that these are intended to mean the same thing. And 2 cases are adduced in support of this. One is Stokes and Costain and the other is Mellowish.
Yep.
So when you come to look at section 61(1)(a), the concept of ownership, the cessation of which I must demonstrate, means ceasing to be the legal owner. And that's what explains section 67. Because you're not the legal owner as the bailey under an HP agreement. And it is that that explains section 70A, because you are not the legal owner as the lessee under a funding lease. So what is meant by this concept of cessation? It requires you to move from a world in which you had the rights of legal ownership to a world in which you did not have the rights of legal ownership. in circumstances where the statutory code recognises that you may enter into a sale and leaseback, and you may get allowances by virtue of the leaseback, but you get them as deemed owner.
Can you remind us which of the statutory provisions which expressly contemplate sale and leaseback? You said there was some provision about that meant it was a long lease, however short it was. But I don't think you showed us that.
It's not in the bundle. I believe it's section 221, but I'll check that over the short adjournment. We can perhaps find you.
Are there any other provisions you expressly contemplate an instantaneous sale and leaseback in the code? Well, don't answer it now. But
If your lordship will allow me to look over the short adjournment, I'll
of
come
course.
back to that. But the code recognises the concept of sale and leaseback and makes provision to deal with who gets the allowances in certain circumstances.
Yes.
So this notion of ownership is a legal state of affairs. And we say there can be no real doubt that cessation of that state of affairs requires you to move from a world in which you are the legal owner to a world in which you're not the legal owner. If we then look back to section 61 itself, in the first volume of authorities, there are references in section 61 to a permanent change in a state of affairs. So section 61B, loss of possession that is permanent. 61C, abandonment. 61D, ceasing to exist. They're all permanent changes in relation to the asset, either of its existence or of its use. Or 61F, it's a permanent change in your qualifying activity because you cease it. But there is no reference in 61(1)A to anything other than the question of whether there's a cessation. And that is, as the Upper Tribunal expressed it, it's a snapshot test. Have you ceased to be the legal owner?
On the face of it, saying it's a snapshot test does seem to run, or potentially run, counter to the underlying theme of the Ramsey cases from the very beginning, but the whole need to look at composite transactions as a whole.
My lord, yes, but having first identified the requirements of the particular provision one is concerned with, which is why they say in both Mawson and in UBS, it depends. One can't proceed on the basis that this is tax motivated and therefore to be seen as a whole, and therefore it cannot meet the particular statutory requirements. What you've got to identify is what are the particular statutory requirements.
Well, I mean, I follow that, but there's perhaps a risk of the argument becoming slightly circular at this point. I mean, the argument against you, as I understand it, is that the verb to cease is an ordinary English language. No doubt what it means in the ordinary way, but to say it is confined to meaning a requiring one to concentrate on a particular point of time is prima facie counterintuitive, because cessation can be immediate, it can be a process, or it can be the result of a whole series of transactions. And what is the correct, as it were, way to analyze it does means you have to look at the whole situation in the round, don't you? At some point, even there's an iterative element in all of this. You have to have a look at the statutory test, but also at the facts and test them against each other.
If I imagine that loss of ownership could take place in conceptual stages over a 5-day period. So on day 0, you are the owner, and on day 6, you're not. I would accept my Lord's observation that you've got to ask, did you cease to be owner? And if so, at what point? But here, the only candidate is a cessation of ownership, legal ownership, on the entering into of the sale agreement. What my Lord I think is putting to me is where you can't divorce the answer to that question from a consideration of the knowledge of the lease and of the put option and of the short term of the lease and of the likelihood of the put option being exercised and the fact that it was exercised and that this was tax motivated.
Yeah.
And I say all of those things are true. Only one of them is relevant. 61(1)(a) doesn't say permanent cessation or cessation whereby there's no continuing use in any way, or cessation for a long enough period for it to really count. It just asks, have you lost the status of legal owner?
And the references to permanence are perhaps double-edged, as reflected in the fact you both rely on them for different purposes.
I say the absence of permanence
Yes.
from 1A is highly significant. And my learned friends seek to say, well, you can imply a notion of permanence because it's in the other parts of the
Yeah.
provision. Well, that process of implication of that sort is not an exercise in statutory construction. That's an exercise in rewriting the statute.
Well, I'm not sure I would agree with that. I mean, statutory construction, again, it's fundamental to any exercise of statutory construction that you have to construe the statutory provision in its context.
In its context.
And so the context, the immediate context, includes several references to permanence. And it could be legitimate as a matter of construction to carry over that notion of permanence as something which at least gives some colour to what is meant by cessation in the first example. Or at least that seems to me not self-evidently an illegitimate argument.
I wouldn't accept that, and you have the reasons why.
No.
But relevantly here, in a world where you have to cater for sale and leasebacks, so continued use in some other guise can't be the distinction. The bizarre thing here is the revenue are trying to cut down the breadth of a disposal event.
Well, I understand that. There's a point made by the Upper Tribunal.
Yes.
That doesn't mean it's wrong, but it would mean if this court were to say, if you sell an asset but you intend to buy it back, it doesn't count as a cessation, so you don't need to bring in a disposal value. It opens up all sorts of possibilities for somebody to say, well, I intend to buy it back.
Yes. So I still get my writing down allowances.
So there's no adjustment to my writing down allowances, even though this piece of kit is long gone. So one can't ignore section 67, deemed ownership. One can't ignore 70A, deemed ownership. One can't ignore the leaseback regime. One can't ignore Mellowish. Mellowish tells us that this is a legal state of affairs. You've either got it or you haven't. And the first tier tribunal did find that the legal effect of the sale agreement was to sell the assets.
And I don't think that's disputed.
Now, is that enough to get me home?
Yes, that's the question.
I accept that's not enough without paying any attention to the context and the purpose of the provision. But once one does that and looks at what the House of Lords said this wording in effect means, they talk about belonging and ownership, but they're the same thing. It is just a legal state of affairs.
I'm trying to think for an example where you might not be the legal owner, but you would still in the real world be regarded as the owner or as something belonging to you. This is quite far removed, but before 1925, if you wanted to mortgage real property, the way you did it was to convey it to the mortgagee with a right of redemption, a legal right of redemption. But in practice, you remained the owner. I mean, certainly in equity, you were regarded as the owner. Is that of any? Maybe it's of no assistance at all. But you could see it's an example where, as a matter of strict law, the conveyance had transferred the freehold to the mortgagee. But in the real world, everybody knew that was just security.
As to the particular property law, I'm in danger of paddling out of my depth, but the fact that that was the treatment as a matter of English land law has echoes in the way that the leasing regime deals with chattels.
Yeah.
And so the modern world is to say, well, in accounting reality, you are really to be seen as the owner. It's on your balance sheet, so we'll give you the allowances. Once you've accepted that post-2006, you've got to find a way to deal with people who move from the world of real ownership to deemed ownership.
Yes.
And the only candidate for that is 61(1)(a).
Again, a possible answer to that might be that, yes, if all you're dealing with is a sale and lease back of an ordinary type, which is not part of a wider tax avoidance scheme. But so there, looking at the thing in the round, you would have no hesitation in saying it should be treated in accordance with the statute for there to deal with just that kind of a situation. But the distinction from the present case, on the revenues case, as I understand it, is that if you look at the situation in the round, you simply can't salami slice the transaction. You have to look at it as a whole, and as a whole, it's designed to place the taxpayers back precisely where they started, with a magical 95% increase in allowable expenditure. Now, on any rational approach, Parliament cannot conceivably have intended that end result to be achievable. So we have to find a way, if we can, legitimately, of construing the legislation in a way that avoids that preposterous result.
That's what my own friends say.
That's what he says. And in many cases, obviously, that kind of approach has worked. You rightly remind us it doesn't always work, which means you have to look at the legislation very carefully.
So I remember that
That's where this breaks down. This is
the
really
Supreme Court says it depends.
depends.
And just to pick up, you're looking at 95%. It's 95% on our illustrative figures. It's not that. I have no idea what the percentage was. I can't remember. But
Thank you. Yes.
But your lordship's observation that one can't not look at this in the round, I am not struggling against.
Yes, it's difficult for you to do so, given the FTT's findings.
Given the
of fact.
findings of fact, yes.
Yeah.
And what I am saying, however, is that even if there is a series of transactions, Supreme Court tell us it's not enough to proceed simply from the existence of a series or from the motivation that put that series together to some necessary conclusion. What one has to do is to identify the particular requirements of the particular provision. And that is not to ignore the rest of the transaction, but it is to discern that some factors or features are relevant to a particular provision that are not necessarily relevant to a different provision.
Can I ask you this? I think you accepted when we were looking at Mellowish, or at any rate, if you didn't accept, I think Lord Wilkinson said that ownership and belonging could be legal or equitable, actual ownership.
Yes. Yes, I think he says legal or beneficial.
Beneficial, yes. Which I think in this context means the same as ownership in equity.
Yes.
Suppose instead of having a put option and call option on the termination of a lease, there was an absolute obligation on the taxpayer companies to repurchase on the termination of a lease. That would, on normal principles, give rise to a specifically enforceable contract, and in equity, that would mean that the taxpayer companies were to be treated as beneficial owners because they had the right under the contractual obligation and obligation to reacquire the legal title, and that would be enough to give them equitable ownership.
It would also mean in this particular statutory code that section 67 would have been engaged.
Oh, yes.
And the effect of being in section 67 is you're taken outside the long funding lease regime.
Yes. My question was going to be, but I can see that it may be a different question. But my question was going to be, is there a difference in the real world between a situation in which you are obliged to purchase on termination of a lease and one in which there are simply matching options under which you may become obliged to purchase in circumstances where the factual finding is the likelihood of your not being obliged to purchase is vanishingly small?
The matching options are not all in favour of the particular taxpayer, not both in favour of the
No,
particular.
no, but actually the finding of fact is there's a put option. You can ignore the call option. There's a put option, and it will, in all likelihood, be exercised. And the chances of it not being exercised are very remote. Does that make a difference to the taxation treatment of the taxpayer? I think you have to say that it does.
Here it does, because it had the effect of rendering section 67 not applicable.
And that has not been appealed. There's no section 67
No.
issue in play.
No, that was decided by the first tier in my favour and the Upper Tribunal in my favour, and it wasn't appealed.
So you can't run the argument, or in fact I think the argument wasn't run, that the put option being very likely to be exercised is to be treated as if it were an absolute obligation to purchase, because that argument,
That was, or a species of that argument was issue 2.
yes, I see.
Quite put in those
It wasn't
terms.
quite put in those terms, was it? No. But in any event, we're not dealing with a section 67 argument. Thank you.
So my Lord Justice Henderson has my answer, but it is about the focus on the particular statutory requirements of our given provision.
Yes, that's been very helpful. Thank you very much.
So you have well in mind what the first tier decided. There is an exercise I did in the Upper Tribunal that I don't think I need to repeat, which is to walk through the first tier paragraph by paragraph. But the upshot of the first tier's conclusion, and this appears from 258 onwards, is where you haven't satisfied the terms of 61(1)(a because you intended to reacquire the equipment. That's in paragraph 261(a) Roman 1. And you had a bad tax motive of creating extra artificial allowances on reacquisition. And that's paragraph 261(a) Roman 2. Once that is read in light of the fact that the lease was short and the assets were acquired, it means that the requirements of 61(1)(a) could not be met. complaint about that line of reasoning in the Upper Tribunal, which the Upper Tribunal accepted, was that it paid no proper regard to the requirements of 61(1)(a) itself, and it placed reliance upon factors that were not part of the requirements of that provision, whether read singly or together. Now, at that point, you weren't shown by Mr. Milne yesterday, I think, anything of the Upper Tribunal decision. I'm conscious that, of course, you've read it, but it does require some careful consideration. So the Upper Tribunal decision is in Core Bundle Volume 16, for tab 16. To note, paragraph 26, internal page 7, records paragraph 258 of the first tier. The FTT concluded as a matter of law, the appellants gave up legal and beneficial ownership of the assets and reacquired it on the exercise of the put option. There is then a perfectly adequate and useful summary of the other findings made by the FTT, and then over the page, paragraph 31, the FTT's conclusions. Paragraph 38 is headed the grounds of appeal, and that identifies the then issues 1, 2, and 4. And then at paragraph 42, the Upper Tribunal looks at issue 4 first, which is not before this court, but it is useful to read that in due course, because as the Upper Tribunal made clear, it does throw helpful light on the later consideration of issue 1. So this was the double duty point, and was the first tier right to find that there was something unexpected or unusual or unwarranted about doing double duty? And the Upper Tribunal concludes rightly that those fears were misplaced. And once one understands how the legislation operated, our construction of the statutory formulae was right, both as a matter of language, as a matter of principle. Of course, this scarcely needs saying, but both members of the Upper Tribunal, long experience of technical tax matters. So that was their conclusion on issue 4, not appealed. And paragraph 62, issue 1, heading Authorities and Principles, we adopt in their entirety a summary there by the Upper Tribunal of the current state of authorities. They start with Mawson, they had the benefit of Rossendale, they also looked at Carreras and Scottish Provident. So we accept and endorse all of that. And it's paragraph 76, heading the error of the FTT. And at some stage, I invite the court to read all of this part of the judgment.
We have read the Upper Tribunal judgment, Mr. Peacock.
Read and reread.
Okay.
But the thrust of what the Upper Tribunal say is that once one understands the proper scope and requirements of section 61, being the particular provision, and once one discerns specifically what it requires, once the first tier have concluded that there was a loss of legal ownership, the other facts or features were not material to the inquiry as to section 61(1)(a). And that's encapsulated in 79. In our judgment, the FTT lost sight of the fact that the particular provision it needed to construe, given the way the revenue put their Ramsey argument, was 61(1)(a). And it's that that leads them at paragraph 81. I should go back to the end. Paragraph 80 identifies some of the features that the FTT relied upon, and they're numbered Romans 1 to 4. The Upper Tribunal concluded, without an appropriate grounding in a conclusion as to the true construction of 61(1)(a), those factual findings are insufficient to support the FTT's determination that the revenues Ramsey argument succeeded. And it's that that lead them to their next heading, the correct interpretation of 61(1)(a), purposively in 81. And then at 82, in our judgment, the following features of section 61 and the statutory code of which it forms part are relevant to the construction of the phrase ceases to own. And they then set them out 1 through 3. And then the balance of this part of their decision is to consider the significance or otherwise of those features. And in particular, they conclude that the fact that this was tax motivated is not material. The fact that it was designed to be leased back and continued to use, not material. The fact that the lease was short, not material. The fact that you intended to reacquire and did so, not material. So we adopt in its entirety the reasoning of the Upper Tribunal. We say they got this right for the right reasons. What you heard from Mr. Milne yesterday doesn't undermine that conclusion. We say the learned friend's case in effect amounts to saying, well, you didn't really cease to own because you continued to use them and you intended to reacquire them. For the reasons I've set out this morning, that's not good enough as an assertion. I quite accept taking my Lord Justice Henderson's point, but we'll pause there. I think that's a rather rum conclusion. But it is a product here of the particular role and requirements of 61(1)(a). It's a product of this being a pre-GAR transaction. Product of the arguments the revenue ran in the first tier about ground one. It's also a product in part of the arguments that are no longer pursued in this court. The single most important reason is that Ramsey is an exercise of statutory interpretation and it is not a broad spectrum antibiotic. Well, at that point, I was going to move to ground 2.
Would you rather do that at 2 o'clock? Yes. How are you doing for time? I anticipate you're well on track to finish.
I would hope to finish by 3:15, 3:30.
Does that give you, Mr. Davey, and you, Mr. Milne, sufficient time to reply?
I hope so. My auditors, I hope so.
I haven't heard what's said on ground 2 yet, but
Okay.
I'm sure things will be fine.
Very well, 2 o'clock.
Flores.